The Trump University settlement, a case study in consumer protection and court-managed restitution, in one of the most high-profile consumer fraud settlements involving a future U.S. president. Trump University reached a $25 million class action settlement in 2016, just days after Donald J. Trump won the presidential election. The lawsuits, which had been winding through the courts for years, alleged that Trump University and its operatives misled thousands of students with false promises of real estate mastery and insider knowledge. The core accusation was simple. Trump University was not an accredited institution, and many students felt they were lured into spending tens of thousands of dollars under deceptive marketing, upselling tactics, and exaggerated claims of access to Trump's secrets of success. The litigation consisted of two federal class action lawsuits, Cohen v. Trump and Lowe v. Trump University, as well as a parallel civil suit brought by the New York Attorney General, who accused Trump of violating state education and consumer protection laws. Under mounting pressure and facing the unique circumstance of impending presidential inauguration, Trump agreed to settle the cases without admitting any wrongdoing. The settlement was structured to provide financial restitution to an estimated 8,253 eligible former students, most of whom had purchased access to live events, costly in-person seminars marketed as transformational real estate coaching experiences. Each claimant's eligibility and refund amount depended on how much they spent, whether they had received any prior refunds, and how many others submitted valid claims. To manage this complex claims process, the court appointed Epiq Systems Inc., a nationally recognized firm that specializes in class action administration. Epiq's role was procedural, not political. They did not influence legal decisions or negotiate refund percentages. Their primary responsibilities included disseminating notices to thousands of potential claimants via direct mail and media, publication, creating and maintaining the online claim portal, reviewing submitted documentation and verifying eligibility, calculating individual settlement awards based on a pre-approved formula, dispersing payments once all legal challenges were resolved. Claimants had until March 6, 2017, to file their paperwork. By the close of the claims period, over 3,700 former students had submitted documentation. Initially, refund estimates hovered around 50%, but due to the relatively moderate number of claims, the average refund amount rose significantly. In April 2018, after a challenge to the settlement was dismissed by the Ninth Circuit Court of Appeals, Epiq began issuing checks to eligible individuals, many of whom received approximately 80 to 90% of what they had paid for the live events. This was considered a victory for the claimants and a rare moment of meaningful accountability in a high-dollar educational fraud case.